in practice, qualified immunity is unqualified impunity. You know, the cases go on, and it's important to hear their stories. There's a new podcast that just went up called Unaccountable. It's available wherever podcasts are gotten. It features Aloe Black, myself, Danny Glover, Van Jones, Killer Mike. And there's a new book. Anyone got that book? Well, there's another book that came out called Above the Law. And it tells the story of 16 people whose rights have been denied based on qualified immunity. We will be going to the state Senate offices and delivering those books after this event. You know, the will of the American people is clear. They know that ignorance of the law is no excuse. And 80% of them agree that police should be held to the same standard as the rest of us. They think qualified immunity is absurd. And you can see the data here on this sign from the Cato YouGov poll. The people who get abused by the police don't look like me. They're usually poor and disproportionately black. But it is only when people who do look like me stand up and demand it that we will finally eliminate qualified immunity and cops will be held accountable. Thank you. Woo-hoo!
Thank you, Ben. We will now hear from Jay Schweikert from the Cato Institute.
Thank you very much. My name is Jay Schweikert. I'm a research fellow with the Cato Institute. And for 3.5 years now, the Cato Institute has been engaged in a strategic campaign to eliminate the doctrine of qualified immunity, because we see this as one of the most fundamental pathologies in the criminal justice system. What I'd like to do is explain in a little bit more detail exactly what qualified immunity is, how it works, and address some of the most common misunderstandings about the doctrine. So the best place to start to understand qualified immunity is with a federal civil rights law that we generally call Section 1983 after its place in the U.S. Code. This is one of the most important laws ever passed in the history of our country. It was passed in 1871 by the Reconstruction Congress and was intended in large part to protect the constitutional rights of all Americans, but especially recently freed slaves. And it's a very simple law. It says, any person who violates someone's constitutional rights shall be liable to the party injured. It's a very straightforward, your rights were violated, you get a remedy. But starting in the 1960s, this body here, the Supreme Court, effectively rewrote Section 1983 when it created the doctrine of qualified immunity. And under this doctrine, it's not actually enough for a plaintiff to show that their rights were violated. They also have to show that the defendant who violated their rights also violated clearly established law. And that phrase, clearly established law, is the key to qualified immunity. Because in practice, what it usually means is that a plaintiff has to find a prior case already decided in their jurisdiction where someone else's rights were violated in nearly the same way as theirs. In other words, whether or not a victim can get relief for a violation of their rights doesn't turn on whether their rights were violated or even how serious the violation was, but on the happenstance of the fact patterns of prior judicial decisions. That is as illogical as it is unjust, and it is plainly contrary to the terms of Section 1983. One of the most important things to understand about this clearly established law standard is that it is not a good faith defense. Many law enforcement organizations have repeated the misrepresentation that qualified immunity only protects officers acting in good faith. That is not true. When officers are genuinely acting in good faith, their actions are protected by the Fourth Amendment itself. In other words, when police are acting in good faith, they're not actually violating anyone's rights at all. So they don't need qualified immunity. But qualified immunity kicks in when an officer has acted objectively unreasonably, but where the specific facts of their misconduct don't match the facts of prior cases. And to give just a couple of very simple examples, in a case called Jessup versus City of Fresno, a federal appellate court granted qualified immunity to police officers who were alleged to have stolen over $225,000 in cash and rare coins while executing a search warrant. Now, obviously, those officers weren't acting in good faith. They did not think they were acting lawfully, and that wasn't the basis of the decision. All that mattered to the court was that it had never addressed this exact question before. Another example, a recent case called Frazier versus Evans, where the 10th Circuit granted immunity to police officers who knowingly violated a man's First Amendment rights to record the police in public. He had reported these officers using excessive force in an arrest, and they harassed him, threatened to arrest him, and conducted an illegal search of him, all because he did that. Now, these officers had received explicit training that citizens do have this First Amendment right, and they ignored that training. But they still received immunity, because that particular circuit court had not yet addressed this exact question. So this doctrine is not protecting good faith decision making by professional police officers. It is protecting unprofessional police officers. And so far from actually protecting the law enforcement community, it's actually hurting them as well. Because when even if professional officers don't commit constitutional violations, when their unprofessional colleagues are not held accountable, they suffer a reputational loss too. And when citizens don't trust or don't respect the police, that makes the job of policing more difficult and more dangerous. So professional law enforcement officers have as much to benefit as anyone from ending the doctrine of qualified immunity. This is one of the most important issues in criminal justice right now, and it is an essential component of any policing reform passed by Congress. Because no matter what Congress does, no matter what rules it says about chokeholds or no-knock warrants or anything else, if there's not accountability when those rules are violated, then they're not actually protecting anyone. So that's why Congress has to reform qualified immunity as part of any policing reform. Thank you.
Thanks so much, Jay. We'll now hear from Keith Neely from the Institute for Justice.
Woo! Thank you. My name is Keith Neely, and I'm an attorney at the Institute for Justice. The Institute for Justice is the nation's leading law firm for liberty, and we've launched a project on immunity and accountability designed to address the very problem of qualified immunity through litigation at this court and through legislation all over the country. Jay did a fantastic job in explaining what qualified immunity is, and I want to talk a little bit further about some of the more egregious examples of what qualified immunity looks like in action, particularly in the context of police violence. Just a couple of years ago, a case came through the Sixth Circuit called Latitz versus Phillips, and it involved an officer, Officer Phillips, who pulled over a man as part of a routine traffic stop just outside of Detroit, Michigan. The officer saw in the glove compartment box what he believed to be marijuana and prescription pills. Instead of rationally assessing the situation, the officer immediately withdrew his firearm. This naturally scared the motorist, who fled, and started a 4-minute-long police chase in which the officer repeatedly rammed the car in an attempt to push the driver off the road. Once he succeeded, the officer ran up to the driver's side window and shot the driver 3 times in the chest, killing him. When the case went before the Sixth Circuit found that although the officer had clearly violated this man's Fourth Amendment rights, that because the Sixth Circuit had not addressed this precise set of facts before, qualified immunity applied. And therefore, even though the officer was fired from his job, and therefore even because the officer had been warned about violating department policies repeatedly, that officer did not face civil liability for causing the death of that man. These are the consequences of qualified immunity in practice all over the country. And I want to give another example, this time involving one of our clients at the Institute for Justice, a woman named Shanice West. Shanice lived in a home in Idaho, and when she walked out one day, she was greeted by police officers who were searching for her ex-boyfriend. Hours earlier, he had been at her home, but he'd since left, but she nonetheless cooperated. and gave police the keys to her home and gave them consent to search it. But police did not use her keys. Police instead decided to set up siege around her home and bombard it with tear gas grenades for over an hour and a half, destroying the home and destroying the contents within. Only after they bombarded the home did they use the keys that she had given them to go inside and discover that he was not, in fact, there. After causing tens of thousands of dollars of damages, they claimed qualified immunity in court and they won. Because courts, again, had not addressed this precise set of facts. Ben said it best when he said that qualified immunity is nothing more than unqualified impunity to ignore the law. But the Constitution says that no one is above the law. And if Congress wants to take that seriously, as Jay said, any reform about police, any reform about holding police accountable has to start with ending the doctrine of qualified immunity. Because as long as that doctrine remains in place, police officers will continue to abuse the rights of individuals without regard and without consequences in our court system. And that is a huge problem that this country must address. So please, Congress, end qualified immunity, and let's put this country back on track toward actually holding the Constitution and using it and holding police officers accountable. Thank you.
Thanks so much, Keith. We will now hear from Joseph G. Varghese, the Executive Director from Our Revolution.
I want to start with a call and response. When I say equal justice, when you say under law, equal justice?
Under law!
Equal justice?
Under law!
Equal justice?
Under law!
My name is Joseph G. Varghese. I'm the Executive Director of Our Revolution. And today we're gathered outside the Supreme Court, above whose entrance is etched the words, equal justice under law. This is the foundational principle of the American legal system. It was enshrined in the 14th Amendment, which was passed after the Civil War to protect the civil rights of newly freed slaves. Equal justice means that all Americans, whether black or white, rich or poor, are equally entitled under the law to enjoy their life, their liberty, their economic security without interference from the state. But the truth is, the phrase equal justice under law remains an unrealized ideal in America, even 150 years after the passage of the 14th Amendment and the statutes that gave it meaning. The deaths of George Floyd, of Breonna Taylor, and countless other nameless souls remind us that state-sanctioned violence against the poor and the powerless, whether it's black folks, brown folks, indigenous people, state-sanctioned violence continues to this day unabated. And one reason that George and Breonna didn't receive equal justice under the law is because in 1967 the Supreme Court promulgated the doctrine of qualified immunity that protects rogue cops who violate the constitutional rights of American citizens. Qualified immunity simple means this. It means it gives cops a legal license for law breaking. Qualified immunity means the police can violate civil rights with impunity. And qualified immunity means that the police are empowered to dispense unequal justice and yet remain above the law. This doctrine of qualified immunity, we believe, is unconstitutional and it should be abolished. Our Revolution members are committed to organizing, to restoring the promise of the 14th Amendment, to restoring the promise of equal justice under the law. We're calling on members of Congress, we're calling on state legislatures, we're calling on the courts to all take action to abolish qualified immunity. We're proud to stand as a part of a diverse coalition. Conservatives, progressives, moderates, all agree it's time to end this doctrine. And our Revolution members are going to be working with Ben and Jerry and with our diverse coalition, which represents millions of Americans, to make sure that every American receives equal justice under law. Say it with me. Equal justice
Under law.
Equal justice
Under law.
Equal justice
Under law.
Thank you.
Thank you so much, Joseph. That concludes the speaking portion. We're happy to entertain questions if anybody has any. Ben, would you like to come back here and join us?
Thank you, Jerry.
There's also ice cream.
Ice cream, yes, don't forget the ice cream.
And Ben, can you tell us about the brochures you were handing out?
Oh yeah, the brochures, kind of answer the objections of the Fraternal Order of Police. They put out a bunch of myths that are untrue, and the brochures give the truth about the situation. I mean, essentially, what we've got is, a whole bunch of police officers who are currently immune from prosecution, and they like it that way.
We also have two handouts that are from the Cato Institute that we invite people to take.
And a letter from 70 police commanders also asking to overturn, demanding to overturn qualified immunity.
Well, thank you so much for coming, and let's eat!
Yeah, let's eat.